5 seconds to go. Start. The appellants used to live in a village far from Latur. However, no reason is given in the FIR as to why the appellants and their son had visited her house in Latur on that day. Furthermore, there is not even a whisper in the FIR about the complainant conveying the news of the pregnancy to the appellants or their son. It is unusual that when the allegations under sections 312 and 313 of IPC are levelled against the appellants, such an important fact surrounding her pregnancy and its knowledge to the appellants is not to be found in the FIR. It is categorically mentioned in the FIR that the appellants brought the poisoned food pre-made from their village, and hence it would mean that they would need to have prior knowledge about the pregnancy of the complainant. No such communication or intimation is alleged by the complainant in the FIR that would even remotely lead to the conclusion that the appellants were aware about the pregnancy of the complainant. This court, in the case of State of Haryana and others versus Bhajanlal and others, after considering all the earlier precedents, has laid down principles which the High Court must consider while exercising its jurisdiction under Section 482 CRPC for quashing of proceedings. It will be relevant to refer to the following observations of the court in Bhajanlal. In the backdrop of the interpretation of the various relevant provisions of the code under Chapter 14 and of the principles of law enunciated by this court in a series of decisions relating to the exercise of the extraordinary power under Article 226 or the inherent powers under Section 482 of the Code, which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such power could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice, though it may not be possible to lay down any precise, clearly defined, and sufficiently channelized and inflexible guidelines or rigid formulae, and to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. Where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused. Where the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offence justifying an investigation by police officers under Section 156(1) of the Code except under an order of a magistrate within the purview of Section 155(2) of the Code. Where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offence and make out a case against the accused. Where the allegations in the FIR do not constitute a cognizable offence but constitute only a non-cognizable offence, no investigation is permitted by a police officer without an order of a magistrate as contemplated under Section 155(2) of the Code. Where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. where there is an express legal bar engrafted in any of the provisions of the code or the act concerned, under which a criminal proceeding is instituted, to the institution and continuance of the proceedings, and or where there is a specific provision in the code or the act concerned providing efficacious redress for the grievance of the aggrieved party. Where a criminal proceeding is manifestly attended with malafidis, and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. It can thus be seen that this court has held that when the allegations made in the FIR or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute a case against the accused, the High Court would be justified in quashing the proceedings. Further, it has been held that where the uncontroverted allegations in the FIR and the evidence collected in support of the same do not disclose any offence and make out a case against the accused, the court would be justified in quashing the proceedings. In the present case also, as discussed above, the facts, when taken at face value, do not reveal any specific instance of cruelty committed by the appellants herein. In our view, only stating that cruelty has been committed by the appellants herein due to some reason would not amount to the offence under section 498A of IPC being attracted. The next allegation regarding a specific incident relating to the miscarriage being caused by the appellants herein has also been discussed above. A bare perusal of the allegation and the analysis of the same, when compared with the statement of the doctor, reveals that even if the allegations are accepted at the face value, it would not prima facie make out a case against the present appellants. Stop.